Good morning and welcome to the Utah Court of Appeals. We have a hybrid argument this morning set in State v. Gilling. And I'll begin just by thanking the parties for your accommodations. We had to shuffle the calendar a little bit, and so we appreciate your willingness to appear on the calendar today. I am Judge Oliver, and I will be chairing this panel. I am joined to my right by Judge Orm, and on my left to Judge Tenney. It looks like everything on the hybrid hearing is going well so far. So if we could have the parties make their appearances for the record.
Hannah Levitt-Howell on behalf of Mr. Gilling, Your Honor.
All right, thank you.
Daniel Boyer for the state.
All right, thank you. You both are experienced advocates here, and I see that there is 12 minutes on the clock. So Ms. Levitt-Howell, I assume that means you've reserved 3 minutes for rebuttal?
That's correct, Your Honor. Thank you.
Okay. And I do just want to note, in case anyone is watching or for those that are here, we have Ms. Levitt-Howell on video, and on our screens on the bench, that is to our right. So to look at her when she's speaking, we will be looking to the right, which may look a little strange to everyone else on the video. And then Ms. Levitt-Howell, when Mr. Boyer is presenting, we obviously will be looking straight, and so you'll probably have a different view as well. But I just make that clear to say we are doing our best to pay attention to the advocates before us. And with that, Ms. Levitt-Howell, we'll have you begin.
Thank you. Good morning, Your Honors. Mr. Gilling presents 3 issues on appeal, and I'll address each in the order they were briefed. First, the state's expert provided impermissible anecdotal statistical evidence. And just by way of road mapping, the state doesn't appear to contest the fact that the testimony was inadmissible statistical evidence. And so instead they argue that the evidence was admissible because counsel either invited the error or maybe opened the door. But both of those arguments are wrong, and I'll address them in turn. So counsel's statement was that we may have opened the door, but I don't know that false allegations was specifically noted in the statement. And that shouldn't be seen as inviting this error for 2 reasons. The first is that the court had already ruled on the issue by the time counsel made that statement. And the state hasn't provided any case law that would suggest you can invite an error after it's occurred.
And can I ask,
such thing as endorsing an error after the fact and rendering it invited. You can't sign off moments later, in other words.
That could be possible, Your Honor, but the state hasn't provided that case law. This court certainly could make that case law, but that kind of bleeds into the second issue that it doesn't, I don't think it's a fair reading of the statement to say that counsel was actually signing off on that. And when we look at the whole sidebar in context, counsel was very repeatedly objecting to any sort of anecdotal statistical evidence. And here, I think the fairer reading is that counsel was maybe acknowledging that the door had been opened to something regarding false allegations, but counsel never acknowledged that the anecdotal statistical evidence was fair. And when we look at what counsel actually asked the expert, and that's kind of moving into the opening the door argument itself instead of the invited error.
Before you get too deep into the merits of the...
Go ahead.
Sorry. Okay. Before you get too deep into the merits of the opening the door problem, as a threshold matter, if a district court determines that a party opened the door for something, is that a discretionary decision? Is that part of the decision reviewed for an abuse of discretion?
Your Honor, I think it should be analyzed the same way that any evidentiary question is analyzed, which I should know off of the top of my head, but I'm having a hard time. I think it's abuse of discretion.
I don't mean that as a gotcha question, but it does feel to me like that's part of what we've got to figure out here. Because I may have missed it, but I didn't see any case law cited as to whether that is or is not part of the discretionary. Assume that some combination of us thinks that it is discretionary. How would it be an abuse of discretion on this record for the district court to think that the door had been opened, given what had been talked about?
I guess, and maybe I'm misunderstanding your question, Your Honor, but that feels like it's just the merits of the question.
Yeah. Walk me through. Why would it be an abuse of discretion here for the district court to think that where the defense counsel in cross-examination had brought up the subject of false reporting even within the context of experts' experiences. How would it be an abuse of discretion then to let the state try to quantify that?
Your Honor, it's an abuse of discretion because counsel was really trying to cabinet in to give me these two examples. All counsel was ever talking about is give me the kind of situations where these false allegations happen. And then, right, he talks about, right, people are having problems or when, right, there's some sort of emotional other distress. I don't think that's necessarily important for this discussion. But once he talked about those like general situations, that's when counsel kind of drilled down and said, and you've seen that, right? Like that's played out in your practice. And so that's where I think counsel is acknowledging, sure, maybe we do need to quantify something, and maybe it's fair to ask, how many times have you seen false allegations? But that's a very different question than how many times have you seen false allegations out of how many, right? It's the out of how many piece that really pushes this over the edge here, that it's a totally different statement for an expert to say, I've seen false allegations twice in my career, than it is to say.
But if the state's not allowed to ask that follow-up question, don't you think that at least some jurors might start imagining in their head how frequent they think those recounted incidents actually were? I mean, aren't they already going to be kind of doing the math in their own heads? So why doesn't the state get to put some concrete numbers to that? I've just got to think that once expert starts talking about his experiences, somebody's going to start thinking how frequent they think it is that he's talking about, right? So why doesn't the state get to explore that?
I think it's for two reasons, Your Honor. And the first is that the line has to be drawn somewhere, right? I mean, evidence is permissible up until the point that it's not permissible, and sometimes that's not always a clean line. I think it's a fairly clean line here, though, because whether the jury is instructed that they should look at the evidence, they should consider the actual testimony, the actual facts. It's once the state is allowed to say things like 2 out of 1,000 this only happens 2 out of 1,000 times, that suddenly the jury's invited to go a step further than just, wow, that seems like this is pretty infrequent. And they have a concrete number where they can say, this is happening 0.2% of the time. That's just, that's incredulous to me to believe that this is one of those 0.2 percentage points.
And I want to make sure I understand your IAC argument with respect to these questions. Is your argument that the IAC occurred at the original question being asked, that the court then said opened the door, or was it the IAC occurred when counsel agreed or conceded that the door had been opened, or is it both? I wasn't clear.
It's both, Your Honor. So I think it was ineffective to concede the point. I don't think that counsel conceded the point, but if this court disagreed and thought that counsel had conceded the point, that would have been ineffective. It would have been ineffective to concede a point that he hadn't conceded.
Okay, so you're saying then that it was ineffective to ask this line of questioning in the beginning, to ask how if the expert had seen false allegations in his practice. Is that where you're then identifying the IAC?
That's the second piece, Your Honor, yes. So I think we're arguing, I'm not trying to dodge your question, but I think our first part is that counsel was ineffective if he conceded that he made this point when he didn't make that point. But if this court thought that he did make that point, then it would have been ineffective for him to be opening the door to this kind of anecdotal statistical evidence when it was really unclear that he had any purpose for it. And that's where the fact that, right, counsel does drill in closing argument to some of those more broad trends that expert had talked about generally, but counsel never references those actual two people that the expert had thought was lying. Whereas the state, on the other hand, I mean, I think some of the quotes from the state's closing argument are quite impactful. The state emphasized that the expert had said, quote, in his 14 years as a clinician, that roughly 2 to 4 of them, approximately on a conservative note, out of 1,000 sexual assault victims that he had helped, roughly 2 to 4 of them, he sort of got the feeling was maybe it was false. And then again, it stresses that that's a conservative number because expert is a scientist, a psychologist who needed to have a healthy skepticism. And then finally, the state concludes that when you put the numbers to it, it equates to less than 1%. I mean, so once that number was out there, the state really.
But didn't the state also essentially walk back from that a little bit in closing as well? Because the state says, something to the extent of, well, those numbers are in a therapeutic setting because that's a clinical practice. That's not necessarily the same here in a courtroom about false allegations. So while I take your point that the state, did highlight the testimony that was given about his experience, they also seem to distance themselves from it in some way to say, well, that's clinical practice and not in a courtroom. The expert didn't say anything about false allegations in a courtroom or how often they might occur. What do we make of that? Doesn't that in some way mitigate the harm that you're pointing to from the state's argument?
It doesn't, Your Honor, for a couple of reasons again. First, the expert himself, I think the state tries to downplay some of experts, right, shuffling of things here, but the expert was pretty clear in my reading of things that this was the most that he thinks could have lied to him, that he was really, those were the only people he was convinced had lied, and that it was really important that he placed a really heavy burden on analyzing the truthfulness of the allegations that people had given because it would impact their treatment if he hadn't. And right, he gave all of these reasons why he needed to be real with himself and with his patients about their truthfulness. And second, I think there is, I don't think it would be unreasonable for a juror to conclude that people have every incentive. If someone is choosing to go to therapy, there's no reason to lie to a therapist. But people might have reasons to lie in court, though certainly the penalties for lying in both places are swapped. So I don't think that the state distanced itself far enough. And even if there was a little bit of distancing about how applicable those stats were, if anything, the state was still telling the jury this is incredibly uncommon right, and not just uncommon, but 0.2%, less than 1% is what they said. And I think the Utah Supreme Court's quote from Rammel is quite instructive here, that I'm sorry, I have it right here, that they emphasized probabilities cannot conclusively establish that a single event did or did not occur and are particularly inappropriate when used to establish facts about whether a particular individual is guilty.
We have had cases since Rammel that have affirmed even where a district court allowed some statistics, right? So,
that's true, Your Honor.
So
yeah.
it's not a per se prohibition on statistics, is it?
It's not, Your Honor, and I think that actually is useful that, right, this court has had, as I said, 5 of these cases in the last 18 months, and there, I think the takeaway is that it needs to be an actual statistic. I think this court has been less convinced by language like rarely or commonly, and that it needs to be something that is not quantifiable, like right, I think this court has looked at delayed disclosure and recantations or the amount of drugs and said, we actually can't put statistics on that, so this is fair to give statistics. And then it also needs to be going to the truthfulness of someone. And here it is going to the truthfulness. It's an actual statistic, and I think it's impossible to say an actual statistic of how many people are lying.
Can I take you to the alibi issue, unless we want to stay? You're going to be at zeros before my question's done. Ignore the zeros. As to the alibi issue that's raised in terms of the direct appeal, it seems like everybody's at the same starting place, which is that the alibi notice was given short of 10 days, right? It was given a date. Okay.
Yeah.
And I'm looking at the statute, and the statute very clearly in subsection 3 says, quote, the court may exclude the evidence offered. And we've got case law talking about how that's a discretionary decision with the district court. And I'm struggling a little bit with the following. If we were to write the rule the way that you want us to write it, it feels like we would be almost writing in a limitation in that statute that doesn't seem to be there. I mean, the statute just sort of at a base level seems to say if the notice is given short of 10 days, the court may exclude it. And I think you would be essentially having us have that statute say may exclude it if it's reasonable to do so or something, as opposed to what the state's telling us, which is, look, if you violate the statute, the court can exclude it full stop. How would we get there consistent with the statute to place a limitation on the court's ability to exclude?
Your Honor, I think the standard from NRA DAT is important, right? That the overriding consideration in evaluating any notice of alibi claim must be the avoidance of unfair surprise or prejudice to either party and not an exaltation of formalities. So here, the statute certainly does allow for the evidence to be excluded, but that's up to the discretion. And it also allows for a continuance, right? I mean, the court may, for good cause shown, waive the requirements of this section. And so where either of those options were within the discretion, I think there are at least 5 reasons why it was really an abuse of discretion in this case. And that first is that the state itself said a continuance was fine, right? If a continuance was fine and wouldn't hurt the state at all, but would impact the substantial rights of Mr. Gilling in that it would impede his ability to present a defense, restricted his, the testimony in presenting this alibi witness, then, then a continuance should have been good enough. And second, it's a very small amount of time. The state provided no evidence that a couple of hours on the weekend.
But why does it have to, though? I mean, the statute draws the line at 10 days. The statute doesn't draw the line in terms of business days. It gives the state 10 days. And I think one of the reasons the legislature may well have wanted to draw that line there is it's not unheard of for law enforcement to work on weekends, particularly for preparing for trial in a case like this one. So why wouldn't the response be, well, the state was entitled to that Friday and that Saturday here to go track down these alibi witnesses? I'm not sure why they have to show all that much more than that to show that they were harmed in some way contemplated by the statute.
That is fair, Your Honor, except for the fact that the state said a continuance would be enough. And then I would just point to the
Right, but the district court doesn't have to grant a continuance just because the state didn't insist that they proceed, right? And that the defense didn't insist, right? This is all within that May framework, right? It's really up to the district court to decide under the circumstances. So while the parties may have been amenable to a continuance, my recollection of the record is that the district court was quite concerned about a continuance because it was going to add something like 9 months to the time before they could get to trial again, due to the scheduling available on that calendar for the district court. And so are we back at square one where it's all in the discretion of the district court?
Sorry, Your Honor, I had a couple of thoughts during your question. So here, I think we are essentially at square one where either answer was within the court's discretion. The court could have excluded everything, the court could have granted a continuance, or under the statute, the court could have done nothing. The court could have allowed trial to continue and just said, sorry, state, that's how it goes. Which I'll point out is exactly what the court said to the defense when the state was late with its witnesses. That's an unfair representation. I think the defense just waived the issue. But the court, right, if they were looking at the tit for tat, the state was late 4 days on their alibi witnesses instead of a couple of hours, not their alibi witnesses, excuse me, just their general witnesses. And that didn't matter to the court.
Can I ask you, I know we're well over time, but can I ask you one question about the ineffective assistance component on the alibi issue? I wanted to make sure I got your answer on this before Mr. Boyer got up. The state is telling us in response to your IAC argument on this that we can't grant ineffective assistance relief or grant the 23B motion because we don't know when defense counsel was told about this particular alibi witness. And I'm wondering if you can answer 2 things for me. They're related, but I sort of think of them separately. One, if we were to look to the record, what's the place in the record that tells us most directly where defense counsel was told about this? And 2, if we don't have anything that specific, why wouldn't you lose under the Strickland presumption plus Burt versus Titlow combo that the state's giving us? So where in the record are we told most directly? And then if there isn't a direct place, how do you win?
Yes, Your Honor. So the place you're told in the record most directly is in the supplemental transcript when counsel says, I'm sorry, I have the page. I can just read through my notes. On page 21 and page 23 of that supplemental transcript, counsel gives the reason and says, we were confused about when we needed to be looking for an alibi. And so that doesn't go directly to when.
But does counsel,
alibi witness?
Yeah, does counsel say there, like, this is when we were told? Because the state's telling us, I think, that the absence of anything in the record telling us this is when we were told is the fatal flaw in your position. So does he say there on pages 21 or 23 of the transcript, this is when we were told?
He does not, Your Honor, which will then move me to your second point, that I don't think that matters, because of the timing of when counsel filed, first of all, right? Counsel gave a reason for why he was late, and it was not that he just found out about the alibi witness. But that would have been a good cause reason, and under the statute, that would have been a reason for the court to grant a continuance.
And I
So-
have a quick follow-up question there. Mr. Gilling would know when he told counsel about his alibi witness. So why don't we have an affidavit from Mr. Gilling in support of the Rule 23B motion indicating when he told counsel about the existence of his alibi witness?
Honestly, Your Honor, because of my oversight, it seemed like an obvious point to me that counsel knew and was late because of the reason that he said he was late, and it seemed like a reframing of the entire issue in the state's response to me, that it seems surprising to me. I don't think it's very logical to think that if counsel had just found out about this witness, that he wouldn't have said, I just found out about this witness, and that's why it's late.
Okay, so it's a presumption then that you had made that counsel knew prior to the time of the filing of the alibi notice, and
It is.
that wasn't the reason and didn't contribute to the late disclosure.
Correct, Your Honor.
I mean,
Sorry.
yeah, go ahead. Maybe this will just give you time to think
Well,
about what you're about to say.
I think to follow up on that timing point, counsel had until 11:59 on Friday to file the notice and ended up filing at some point on Sunday, which means that the only way counsel could have found out about it late was if he was talking to Mr. Gilling on a Saturday. And that seems fairly unlikely as well to me, just logically, that
Why is
if he
that?
found out about it on Friday, then he should have filed it on Friday. This is not a hard thing to file.
Okay, it feels like there have been a number of cases in recent years in which some variant of this issue has come up with the state in criminal appeals about how far the Strickland presumption goes and how far Burt versus Titlow goes. And I take your point that it just didn't sort of occur to you that this may have been a problem, but then the state's coming back and they're saying, look, two things. One, Strickland tells us that we're supposed to strongly presume the counsel acted competently. And then two, we've got this passage from Burt versus Titlow, which seems to say that silence goes against the defendant. And so if there's this issue lurking out there about the alibi notice and when defense counsel knew about it, why don't those two things just say that if you didn't get ahead of that, you lose? Because that's what they're telling us, is that because you didn't get ahead of that, that the Strickland presumption tells us that we have to go their way on that. Why is that wrong analytically?
For two reasons. First, the record isn't silent. The record does give a reason, right? They were thinking about these alibi witnesses when the expert testified earlier. They knew about that. That suggests that they knew about the alibi witnesses. But second, counsel said why it was late. It wasn't that he didn't know about it. It's that he was confused about the dates he needed to be specifying. And then second, I'm sorry, I forgot what the second point was. I'm only remembering the Berber point. So, unless it.
It'll come to you in about 4 minutes. But.
You do have rebuttal, and we have certainly kept you long past the zeros due to our questioning, so we will give you your full time in rebuttal.
Thank you, Your Honors.
All right, Mr. Boyer.
Good morning, Your Honors, Counsel. May it please the court, Daniel Boyer for the state. I'd like to turn first to the door opening issue.
Could I turn you
Yes.
instead first to the continuance issue? The statute speaks in terms of may, and counsel conceded that that means it's discretionary with the court whether to exclude the testimony or not, which suggests that our review of that decision would be for an abuse of discretion. Is there anything in the record let me come at that another way. I don't think there was anything in the record suggesting that the trial court teased that out a little bit. We're going to need a continuance. Oh, how so? Under the statute, you were entitled to 10 days' notice of the alibi witnesses. Instead, you got like 8.5 days notice, and a good bit of that falls on a weekend. Tell me exactly, prosecutor, why it is that being deprived of that day and a half completely obviates your ability to become prepared for the alimony testimony. Why was it a continuance or nothing? The trial court seemed to jump to that, unless I'm misunderstanding, without any exploration or articulation on the part of the prosecutor as to why that lack of a day and a half in a otherwise allowable 10-day period was fatal to the state's ability to get ready for what seems, if the affidavit is to be accepted at face value, fairly straightforward alibi evidence. Sorry for the length of the question, but I think you take my point.
I think I do, Your Honor. First, the good cause requirement falls on defendant under the statute. So in order to even prompt the district court's discretion to allow a continuance, the defendant needs to show good cause. And so it's really a burden on the defendant to do that. The state, under the plain language of the statute, doesn't really have that burden. There is case law suggesting that there, has to be prejudice and surprise. And the prosecution here did explore that, saying that we were genuinely surprised by this alibi notice. We had no notice of this in discovery. It's the first time we've seen these names and this theory that defendant was with these proposed witnesses on the dates in question. And second, he said that I just simply won't have time to prepare a cross-examination, call these witnesses, investigate. So that's the proffer that the prosecutor made to the court. And this notice was received on a Sunday afternoon, so really, assuming the state really got it on Monday morning, had a week to do this investigation. It was not only the timing of the notice that was a problem, it was the inadequate details in the notice. There were several witnesses didn't provide addresses. None of them really provided their location where they said they were with Gilling at the time. So it would have required a lot of legwork for the prosecution to uncover those details and call all of these proposed alibi witnesses within 7 days. But really, it's the good cause requirement that's at issue here. And defendant really hasn't shown anything beyond his control that contributed to this delayed notice.
And I think you make a good point that the alibi notice identified 5 or 6 witnesses who may be called, whereas the motion for remand focuses on what ultimately was apparently the most important of those alibi witnesses, and that probably influenced my comment. That was fairly straightforward. Well, not if you've got all 5 or 6 in play. Had the focus been on the one witness who said he couldn't have been there because he was taking care of me all weekend because I had medical problems. Maybe if the alibi notice, as the 24B motion identifies, had identified just that witness and the particulars of that testimony, maybe the prosecutor would have been able to handle that in the time available and not need a continuance. Does that seem like a fair perspective?
I think it would have been a different analysis, certainly, and perhaps the prosecutor would have, well, I think inevitably there would have been, a more ability to prepare a cross-examination for one witness as opposed to 6.
One witness with a fairly specific story.
A fairly specific story, although lacking in the notice where they were at the time of the alleged offenses, April 11th and 12th. So prosecutor would have had to drill down those, assuming he could get a hold of this witness and prepare for cross-examination in time. So yes, that would be a different scenario, and that's not the scenario that the prosecutor faced here.
And does it matter, counsel raised the issue of the continuance. The state wasn't opposed to a continuance here. And it was the trial court at the end who said no, essentially said no to a, it's not clear to me that there was a stipulation, but there at least seemed to be some positions that both sides were willing to consider a continuance here. Does that matter in our evaluation of the decision by the district court here under the May standard in the statute?
So first, I've disputed that the state's position was that a continuance would be okay. In my brief, I've explained those. The point in the record here is pages 22 through 26 of the April 18th, 2023 hearing. The state was really silent when this discussion of a continuance was going on. There was no affirmative representation by the state that a continuance was advisable or even available. And as the trial court, discussed, this would have pushed out the case 7 months. The case had already been pending for 2 years at this point. So it was within the court's discretion to consider the length of the continuance and its effect on not only the victim, but the criminal justice system as a whole in making its determination. At least there's nothing in the case law to suggest that's not a proper consideration for the trial court to make in deciding in its discretion whether to grant continuance or to exclude the witnesses. And given the insufficient details of the alibi notice, which defendant does not dispute on appeal, the untimeliness of it, and the number of witnesses on this alibi list, the trial court was well within its discretion to exclude those proposed alibi witnesses.
With respect to the ineffective assistance component on that, you've heard the questions I asked opposing counsel. Here's the flip side of it. I feel like this issue has been lurking in our ineffective assistance cases for a while now of just how far we're supposed to take the Strickland presumption plus Burt versus Telo in this kind of scenario. I almost feel like this is the perfect example of the problem, which is, okay, so the defendant points to what seems to be an error from counsel. The error is apparent on the record. Defense counsel does not file the notice within the timelines. The defense counsel in the 23B has given us an affidavit which, taken at face value, seems to provide an alibi for the defendant. She says he was with me that whole weekend, that is the basis for the charges. And then the state comes back and says, well, there's nothing in the record telling us when they're told. And their response is, well, we've put forward our own claim. If you want to explore your defense, great. We can do that in the 23B hearing. One of the things I've struggled with in this case and in other cases where this has come up is what case is it that says that a defendant has to preemptively think of all the responses the state might make and get in front of them before the state has made them? What case says that? And would it be unfair to place the burden on a defendant to initially close down all the silence gaps that the state might come up with later, and if they miss one, then they're out of luck? What case says that Strickland goes that far?
Right. I don't mean to be cheeky, but it's Strickland itself. So it's not only the presumptions inherent to the Strickland analysis, it's the statement, the mandate from Strickland that the information supplied by the defendant is critical to defense counsel's performance. And it's critical to an assessment of whether counsel's strategic choices were reasonable or not. So counsel's strategic decisions depend critically on information supplied by the defendant. And precisely here, where defendant is the originating source of this information, presumptively, he's the one who's telling his defense counsel about these alibi witnesses. That information is critical to forming an alibi defense. And since they're faulting counsel for not effectively pursuing this alibi notice, it's their burden to show that counsel was given timely notice by his client to provide that notice to the court. And that's under Strickland. That's under Strickland
But
itself.
doesn't that potentially work as a defense from your end to their claim? But why do they have to push down the defenses first? I mean, their claim is defense counsel was ineffective for not providing timely notice. They've pointed to record stuff that seems to support that. If the state's going to come back and say, well, the defense of that would be that defense counsel wasn't told in time, why do they have to think of that first? And if it's not this, you guys could come up with 2 or 3 other things that they didn't think of. And if they don't think of them all in advance, then now we sort of put the burden on them to think of all the things first that you're going to think of later. I think that's the conundrum that the courts have been sort of struggling with in these cases, is how much preemptive thinking the defense has to do before you even get a chance to respond. Do you see the point I'm making?
Absolutely. And it's a heavy burden. It's a heavy burden under Strickland to prove that counsel is ineffective and that the decisions that they made were unreasonable. And because of that language from Strickland, and because we're in a 23B context where the defendant is tasked with putting forth the evidence he or she now has, not amassing evidence that might support a claim of ineffective assistance of counsel. That language is from this court.
Let's play that out here, though, in this particular instance. It's a better case for them if counsel didn't know before Sunday when he filed the alibi notice, right? That's a better case for good cause for the defense to present to say, hey, the client didn't let me know until Sunday, and I scrambled and put it together as quick as I could, and I filed it, right? And that on its face seems like a decent run at a good cause basis for failing to file in a timely manner. And so, at least as I took the answer to the question when I asked it earlier, their assumption is that if they had that argument to make at the time before the district court, they certainly would have made it, because that's going to be a better good cause argument than we weren't sure of the dates, and so we were waiting on the dates, and there was this confusion on the dates, and that's the stated reason. So in this case, it seems like it's almost presumed away, because if they had that argument to make, they would have made it, right? So we're basically ending around back at square one, which is the state saying, well, you don't know when he told counsel, and the defense was saying, yeah, we assumed he knew because he didn't say, because that would have been a good reason. And so isn't this all a wash in this particular case, though? I mean, it seems to me that I understand the position the state's arguing with respect to Judge Tenney's questions, but when we actually try and apply it here, it seems that's not the case at all, because they're not asserting that was the situation here with respect to the counsel being informed.
So two responses. On the record, defense counsel at this pretrial motion hearing stated this was part of the reason. Part of the reason was this memory issue that the state's expert was propounding, right? Which really wasn't a reason at all. They were on notice of the dates of the alleged offenses from April 11th, since the charging information was filed. So they never proffered the other reasons, and they always expressed it in terms of this is only one factor, this is only part of the reason. And defendant is tasked with showing what those other reasons were. And I don't think it would have been a good cause argument at trial pre-trial for defense counsel to say it was my client's fault. He told me on the Sunday when I filed this notice, that's why it was so late. Because that would not show good cause. It would show that this was entirely within defendant's control. He just chose to wait until the 14th hour to provide me this information.
But if
that would establish good cause.
If that's what had happened, wouldn't it be an effective assistance for a defense counsel to not have asked their client well before 10 days, do you have an alibi witness? I mean, if it's true, what you're suggesting may have happened, that the defendant didn't tell counsel until too late. Why wouldn't a defense attorney have something of a Sixth Amendment obligation to at least ask their client, do you have an alibi?
Right, and again, it goes back to Strickland. Reasonable investigations depend critically on the information provided by the defendant, but that doesn't have a corollary responsibility for counsel to ask all probable questions that might lead to a reasonable investigation. It's depending upon the circumstances of the case, the law, and the information supplied by the defendant.
I mean, but thinking about it within the context of this particular case, you've got an alleged victim who's saying that she's in the middle of a several-day withdrawal from drugs, that she's asleep in her apartment, and that the defendant came into her apartment and sexually assaulted her. That's the core allegation set forth in the amended information and so forth and so forth. Why wouldn't if Strickland acknowledges and says the defense counsel has an obligation to conduct a reasonable investigation, I'm not sure how far down the list of questions you'd have to get before you'd get to, hey, where were you that weekend? And if he says, I wasn't there, wouldn't the immediate follow-up question be, do you have anybody that can back that up? And so if it's true that the defendant didn't tell him until the eighth or ninth day, why aren't we in ineffective assistance territory for not having found that out much earlier?
Well, and again, it's defendant's burden to put all of that on the extra record proffer in the 23B. It's not the state's burden, and especially in the absence of any record evidence supporting what conversations took place. It really is defendant's burden in proffering the evidence that he believes supports his claims of ineffective assistance to show what those conversations were, and this was fully within defendant's control. He could have supplied an affidavit describing his conversations with counsel. He didn't do that. And that's why he fails to meet the requirements providing non-speculative facts under 23B. I
apologize for putting you on the spot, and feel free to just duck this question because it's a little bit 1,000-foot level. Is it the state's view that in almost every case, if not every case, a defendant needs to file a 23B motion to support an IAC claim on direct appeal? Because if they don't file the 23B motion, you're always going to be able to point to the record gap of, well, we weren't told what defense counsel was told, right? So is it the state's view systemically that this is a de facto requirement, if not an explicit requirement, that there just needs to be a 23B to support any IAC claim?
No, I think there are many cases where there is a sufficient record to enable the court to make a determination about whether counsel is deficient or whether any deficiency prejudiced, and it's common occurrence, and the court has reversed based on ineffective assistance of counsel without 23B.
State versus Maritsky is a good example of that, where counsel neglected to look at, back in the day, what would have been the pocket part, and realized that the defense of habitation defense had been strengthened and was arguing under the prior law. Well, no rocket science to conclude you're arguing a statute that no longer existed and had been substantially upgraded. That's ineffective assistance, or so said this opinion,
Right.
and the prejudice is palpable. So in a case like that, the ineffective assistance claim will be successful. But I think Judge Tenney's point is right. So many of these cases now seem to suggest that we need more in the record than I think Strickland originally envisioned, with its focus on indulging every reasonable presumption and of counsel's competence and the rest. Surely over the course of my career, the 23B practice has grown dramatically, exponentially, I almost said, and I don't think that's an overstatement. But I hope we're not at a point where it's required in every case.
I mean, it's just been feeling to me in recent years like this is an argument that we're seeing with increasing frequency. This is what's prompting me to try to figure this out.
Sure.
Is it feels like we're getting this argument from the state a lot more than I think we used to, which is the defendant makes an argument in the direct appeal saying, here's this thing that went wrong, and then the response we're getting is, well, but you didn't file a 23B, and that could have fleshed out X, Y, and Z. And I feel like we're sort of converging on the point of needing to answer that question directly of, is that really what's going on here? Is that that in your view, short of something just really explicit on the record, if there's not a 23B, that's the end point? Because it feels like that's what we've been nudged to say more than a few times. And I might be misinterpreting, but I feel like that's what we've been being pushed in the direction of being asked to answer.
Right, and Your Honor would be in a better position to kind of assess that. I'm not really familiar with, all of the instances in which we've said that these omissions mean that the defense can't show deficient performance. But I think when we have claims that depend critically on communications between counsel and their client, where investigative decisions about filing depend critically on the information supplied by the defendant, those sorts of claims, the defendant needs to make some sort of proffer to show that the I's were dotted and the T's were crossed. Yeah. And that's just both under the plain language of the Strickland case, but also under Burt v. Titlow and Litherland, and 23B itself, which requires them to put forward non-speculative facts, not to amass evidence that they think might support a claim of ineffective.
It's that line of cases, this isn't a fishing expedition, right?
It's, not a fishing expedition. So if this were a case where it wasn't dependent so much on the communications between counsel and their client, then, well, we might not need there may be no 23B motion. The fact that they've brought a 23B motion suggests that there are gaps that need to be filled in with extra record evidence. So defendant had the opportunity to explain what kind of conversations he had with counsel, to prompt counsel to file that notice, but he neglected to do so. That was fully within his control, and his failure to do so means that his 23B motion should be denied. I realize I'm way over time.
That certainly is due to our lengthy questioning, so we'll excuse it, absolutely.
We ask the court to affirm. Thank you.
Thank you. All right, Ms. Levitt-Howell, you have your 3 minutes for rebuttal.
Thank you, Your Honors. I'd start just by saying it's the state that's fishing with this argument. Strickland does not support speculating about contrary reasons when counsel gave his actual reasons on the record.
Why doesn't it, though? Because Strickland says that we start with a strong presumption that counsel performed competently. I may have mangled the last two words, but the first part I did not. It says strong presumption. And so if we're taking whatever it is that defense counsel did, and we're supposed to strongly presume that they were acting competently, why isn't the implication of that we read between the lines to support a finding of competent representation? Why isn't that it?
Because he gave his reasons, Your Honor. He was late because he was confused about the dates, and it just feels like we're not just reading in between the lines. We're adding something to the lines that that he would hide his real motives, that he wouldn't, point out the good cause reasons that he had for being late here. The record in this case says why he was late, and that should be taken at face value instead of scrutinized and turned on its head and turned into something it's not. My second point is that the alibi statute does let the court exclude evidence, but it also lets the court grant a continuance. And once the continuance was requested, then the statute is no longer what we're using that as that balancing test, but it's instead case law that says we need to look at prejudice, and that if more time would solve the prejudice issue for parties, then that would be the better solution. And I'd also point out that had a continuance been granted, defense counsel could have filed a compliant notice so that there wouldn't be any statutory issues at all, that would have solved all of the problems very neatly.
But that's true anytime someone misses a deadline, right? I mean, if the answer to any deadline is, well, we can just continue it and then there's no problem for anyone, then there wouldn't be any discretion about having a continuance. I mean, and then the deadlines would be meaningless. I mean, deadlines exist for a reason, and you can't, I don't think you can say with a blanket application that just because a continuance could occur or is possible, that is always the reason that should govern, right? And that should be the outcome because we could have a continuance. I mean, that seems problematic on a very high level of applying that framework.
Absolutely, Your Honor. Yeah, and if I insinuated that, then that was wrong. The case law is what then the analysis should be, and the case law indicates that a continuance should be granted when there would be a substantial prejudice, or when there would be prejudice to a party's substantial right, and that if that substantial right wasn't impinged, that it would result in that there's a likelihood of a different result. So I think that's the analysis that we should have been using, and here that is the case. If a continuance had been granted, then there is a likelihood of a different result.
But that is still discretionary, right? That's still within the discretion of the district court to make that decision. Because again, you're saying if it affects a substantial right, then you have to have a continuance. But here it's the defendant who caused the reason to need the continuance, right? So it seems like you can't say that there's an automatic, cure to any issue that you create for yourself because the court then has to give you a continuance. Like that puts us back where I think we were starting, which is that if a continuance is possible or available, then it has to be the outcome. And that isn't the case in our case law.
Your Honor, I guess I'm just reading from State v. Peraza, and I agree that this is discretionary, but it says a trial court abuses its discretion when it denies a continuance and the resulting prejudice affects the substantial rights of the defendant such that a review of the record persuades the court that without the error there was a reasonable likelihood of a more favorable result. And that's citing, that's the Utah Supreme Court, Peraza 2/2020. So I agree it shouldn't, but in these defense cases, perhaps when there are other issues, beyond that, in this case, it was outside the bounds of reasonability. The state, it was arbitrary to allow the state to have no issue with its late witness disclosure and to penalize the defense so heavily when there really was no harm that would have resulted to the state in delaying the case, 7 more months in incarceration. The only issue that the district court raised with that was that that he would remain incarcerated. And I just noticed that I'm out of time, so I apologize, Your Honors. But we would ask that the court reverse. Thank you.
All right, thank you. And thank you to you both for the excellent briefing and for the argument today and answering our many questions that we kept you over for. We will take this matter under advisement and issue a decision as soon as we are able. Thank you. We will be in recess.